right? And you admit to the allegations that you violated free control as filed on March the 17th of 2022.
I did.
All right. Now, let's see, is Mr. Bailey being supervised by Warren County?
Officer Kelly, can you speak to that?
Yeah, I was asking her, so just muted.
Yeah, sure, Honor. He was being supervised by he was supposed to be living in our county, but I believe when he was suspended, back.
All right, so Mr. Bailey, why did you leave treatment? Why didn't you come back to probation?
I had wrote a statement already, but the short version of that, it was more of a faith-based religious program. It was a Jehovah's Witness religion. I don't believe in that faith. I'll get in more details on that.
Well, you don't have to. That's not a problem. I won't make anybody go to a faith-based program against their will. But my understanding is you wanted to go there.
Well, that was the only choice that was given to me by one parent.
I see.
I was going there and no other place.
All right.
And
Okay, so I understand that you didn't like the religion, and I don't know much about the religion, but in any event, why didn't you come to the probation department and talk to them about it?
I got picked up at 1 o'clock that night, the day I left. I got home about midnight, 12:30, when my dad picked me up, and I went straight to work with my family that morning at 8 o'clock. And I was going to give a call or give to see Mr. Walker when I had got home, but that's when the officer was there when he pulled in from away. I honestly never had a chance to give him a call or anything.
Okay, well, let me interrupt you now and tell you that no, you did have a chance. You just chose to do something other than call. When you're on community control, the most important thing in your life is complying with that. Nothing else matters. You know, going to work with your family or whatever, going to work even if you wasn't with your family, doesn't matter. First thing is you have to stay in touch with probation. And you weren't working before, you were in treatment, right? Okay, so you don't just leave treatment and go out back in the workforce. But I can tell you right now, you know, the evidence is overwhelming. Finding a job doesn't keep people from being actively abusing drugs. It just doesn't. We have people who are working full-time jobs and are spending every dollar they make on whatever, heroin and meth, you know, whatever, fentanyl. So, you know, that's just not it. So, you know, poor excuse isn't better than no excuse in a situation. That's not a good excuse. It's a poor excuse. It's crap. So, now, you need treatment. There's no question about it. But we're going to, I'm going to order that you be held in jail and evaluated for residential treatment, either in the STAR relapse program or at a facility that the county probation department, you're going to be supervised out of this county, not out of Warren County. And I don't know, where are you living?
At this time, I'm living in Eastburg.
Good, so you're in Highland County. Well, that's where you belong, so we can supervise you better. So, they'll have you, so I want Officer Kelly, is this your case or Officer Bals's case?
It's Officer Balder's
All
case.
right. So, I want him to be evaluated for either STAR relapse or Massey House or counseling center, whoever has a bed available first. And we're going to order that you successfully complete residential treatment program and aftercare. And I'm writing on your sheet right here that goes back in the file, so if I see you again, I'll look at this and remember, last chance. Not anymore BS about, you know, well, I decided to go to work instead of calling in, I didn't have a chance. That's just total crap. You made a choice, made the wrong choice. But, you know, you've been making a lot of wrong choices, and if you don't start making the right choice, then it's going to be prison. So you'll be held in jail until, a bed is available.
May I, this time, ask you a question? Will, this run together with Warren County, or will I complete this in one?
I don't have any idea what's going on in Warren County, I don't care. I'm worried about Highland County.
Okay,
You're gonna have to deal with Warren County, that's gonna be something else.
okay,
So if that's the case, Ms. Kelly, just go ahead and do, counseling center because, Star won't take him if, there's a holder on him from, Warren County. Do we know if there's a holder on him?
I'm not aware that there is a holder, Your Honor.
Yeah, well, Warren County's kind of slow, sometimes, so they'll probably go, I will say this, Mr. Bailey, I don't know what they're going to do, they may just decide to go ahead and follow along with what we're doing. You're on probation for them for charge out of Warren County?
yes.
All right, well,
I think that would,
that's a different problem I can't do anything about, you'll just have to deal with it,
okay,
all right? So, most likely then, I'd say rather than Star, let's look at Massey House or TRC, or, pipe recovery, counseling center, or whatever, committee aggregates, TCC, TRC, whatever, finding a bed is the earliest possibility. Now, in the event that, a holder comes in from Warren County, you'll have to go over there and see what happens. And if they decide to release you to treatment, then you need to come back here. We're not gonna give you up until you're in a bed. So we'll keep a holder on you until you're in a bed.
okay. Now,
Right.
should I, talk to, Warren County to see what they want to do now? or-
I don't know. I mean, I'm not your attorney. Talk to Ms. Witt or, call your attorney over there. I can't tell you what to do about that.
All right,
All right?
thank you.
All right, and, let's see.
Mr. Boyd?
Boyd, yeah, James Boyd. Yes, thank you. And then, Tessa Henderson. Holsinger, okay. We'll do, Tessa Holsinger next then. Sure, okay. All right. Are you James Dakota Levi Boyd? All right, case number 20, CR 23, State of Ohio versus James Dakota Levi Boyd. This is an evidentiary hearing. Mr. Boyd is appearing by video from the Justice Center. His attorney is William Armstrong, appearing from his office. Appearing from the prosecutor's office is Assistant Prosecutor King. Mr. Armstrong, choosing client both in agreement this matter to be conducted by Zoom rather than him being in person. You're muted, Mr. Armstrong.
Yes, Your Honor.
And you're in agreement with that, Mr. Boyd? Okay. All right. The defendant was put on community control on May 6th, of 2020 on having a weapon under disability, a third-degree felony, aggravated possession of methamphetamine, fifth-degree felony, possession of heroin, fifth-degree felony, and endangering children, first-degree misdemeanor. The court received a notification alleging that the defendant had violated these conditions. That was filed on March the 10th. And alleging he violated Rule 2, failing to report since July of 2021. Rule 3, that he was not living at his last known address. Rule 7, that he admitted to using meth on 7/20/21. Rule 15, he's owed $483.50 for costs and payments that were made. Rule 19, he's not provided any proof of aftercare. And that was signed by Officer Kelly on March 10th. The court notified Mr. Boyd of the allegations, appointed Mr. Armstrong to represent him and set the matter for hearing today. Mr. Armstrong, we had an opportunity to review these allegations with Mr. Boyd.
Yes, sir, we met yesterday, reached the allegations today, James compared to violating all of the rules that was alleged. Notification.
All right. Well, Mr. Boyd, you have a right to have a hearing on this matter, which is what we are here for, in which the state would have to present testimony and evidence that proves to the court that you have violated these conditions. You have a right to have your attorney cross-examine those witnesses. You have a right to present any witnesses or evidence on your behalf as well. Now, in the event that it's found that you have failed to comply with the court's conditions, whether you admit to that or whether we have a hearing and the court makes that decision based on the evidence, one of three things can happen. I can continue community control under the same conditions previously ordered. I can continue with additional conditions that I think are appropriate. Or the third and most serious is I can revoke your community control and send you to prison. And on count one, possible prison terms range between 9 and 36 months. On count one and count 3 and 4 are both fifth-degree felonies, and that is a possible prison term between 6 and 12 months in each. So if you add all those together, that's a total possible sentence of 60 months, which is 5 years. And there's also fines available of $10,000 and $2,500 on 2 fifth-degree felonies of $15,000. You understand that? Has anyone promised you anything or threatened you in any way to get you to make these submissions here today? And you understand the allegations? And do you have any questions about the allegations or the consequences of your making an admission here today?
No, I have nothing to say, though. I did, before I had St. Kelly, I had 2 bowls, and I was in choices for 9 months after that.
Well, the question is whether you provided proof of that or not. That was the allegation.
They have proof, okay, choices, they should.
That's not what we're talking about, to the probation department. So,
Alright, no, I have nothing to say.
okay. So you are admitting then to the violations?
Yeah.
All right. Now, you can talk about that when it comes time for me to decide what to do. Because I am interested in hearing it. All right. Anything from the state regarding the disposition?
Thank you, Your Honor. Given that this is the defendant's first violation since being placed on community control, it does look like there's an ongoing substance abuse issue here. The state would ask to be continued on community control, and in order to complete STAR, there is a bed available at STAR on UP6 here.
Mr. Armstrong?
I hope the court will consider that, Your Honor, and what that James was speaking about, we did talk about that yesterday. He indicated to me that at first, I think he might have been confused that he didn't complete his residential, which the court's aware that he did, but that he did not provide proof that he had been in this place called Choices. I think it is probably the same thing, just what we thought they were going to provide it, but he did not provide proof himself that he had been in Choices for a while. He freely admitted to me, Your Honor, that I think he broke up with his girlfriend for a while, lived under a bridge for one minute, I simply told him that you're on probation, no excuses, you could make a probation officer, you have to follow there. He indicated he understood that, and he was prepared to accept the consequences that's done, and not follow probation. But the court will give serious consideration to keeping them on community control. I think clearly it's a product of him having relapsed.
All right, now, Mr. Boyd, anything you'd like to say? All right, so when was the last time you were in that counseling program?
I have the dates, it was from when I got out to, I think it was May or April of 2021. And then I was in and out of, like a Suboxone, clinic up there, like 2 different ones, but it wasn't too long.
Okay.
It was something to do with that, and had a doctor think on it.
All right. Well, far as that program, one of the things that you need to understand is you're responsible for yourself and can't depend upon everybody else. So the idea that they're going to send that to the probation department, number one, if you don't sign a release of information and give them the information to do it, they're not going to do it. And secondly, even if you do that, it's still your job to contact them and make sure they do. If they tell you they did, the probation says they didn't, then you've got to keep on. So that's one thing. But then they also think of not reporting. That's another thing. Now you have a lot of time hanging over your head. I mean, 5 years is a lot of time. And the number of charges you had, you were fortunate that you got community control, and fortunate that the state's still recommending this. And I agree with that. I think that you do need treatment. So I am going to continue on community control with these conditions. First, you're to successfully complete STAR and aftercare. Secondly, you remain in jail until beds available on April 6th at STAR. Pay court costs. And I'm also referring you to the drug court docket to see if, to discuss that with the drug court coordinator to see if that's something you would be interested in getting into. Because it looks to me like this situation that it may need more time. Because you mentioned about having a job and doing the Suboxone clinic both at the same time, and there's I don't know where the Suboxone clinic was or who it was, but drug court is one thing they look at is working with people to focus on recovery first, and then ease into a job. Because again, I mentioned to the last person you didn't hear this, but just having a job isn't going to keep you sober. Because we have billions of people in this country that are working that are in active addiction and abusing drugs. Fentanyl, heroin, meth, alcohol. It's all it does is means that they're a functioning addict as opposed to an addict that doesn't work and sponges off others or steals. So I think that would be something you should consider. I can't make you do it. You have to want to do it. And we can talk with Ms. Sturgeon about that. She'll have to also evaluate and determine if you're eligible. So, so while you're in STAR, you focus on that, and they'll talk with you about it and decide whether that's something you would like to look into doing. All right, anything further, council? All right, thank you. All right, then the other two cases will be in person over here, Mr. King, and this witness has one case.
What about Tessa Holsinger?
Oh, I'm sorry, yeah, right, we do have to do Tessa Holsinger, okay? Tessa Holsinger, officer.
Okay.
Um, 21 CR 153. 22 CR 64. Previous case. All right, are you Tessa Anne Marie Holsinger? Okay, this case number 22 CR 64. Dale Ohio versus Tessa Anne Marie Holsinger. Ms. Holsinger is appearing by Zoom from the jail. Her attorney is Daniel Witt, appearing by Zoom from her office, and appearing on behalf of the state is Assistant Prosecutor King from his office. The court was informed that Ms. Holsinger had reached an agreement that they wish to present to the court, so we did have scheduled for hearings today, but the court has added it to the docket. Now, Ms. Witt, you and your client both agree with her appearing before the court by Zoom rather than in person.
Yes, we are, Your Honor.
All right, Ms. Holsinger, is that agreeable with you?
Yes.
Now, since you're not in the courtroom sitting next to your attorney, if at any time you need to talk with her about anything, you just tell me and I can put you in her into a breakout room where just the two of you can talk, and no one else will be able to see you or hear you, okay? Alright. Now, this whole center is charged with aggravated trafficking of methamphetamine in fourth degree felony, and aggravated possession of methamphetamine in fifth degree felony. And I believe the trial is set on this on April 28th. I think we have a pre-trial coming up on the 13th of April. Now, I've been presented Ms. Holsinger with a plea of guilty form, which indicates you're going to withdraw your not guilty plea, plead guilty to count one. It's a 3-page form that's been prepared by the prosecutor's office from their computer. And on page 3, there are signature lines, and there's a sentence that says, I enter this plea voluntarily. And I'll hold that up to the camera, and it looks like that's the signature. Tessa Holsinger, is that your signature there? And when did you sign this document, Ms. Holsinger? And was Ms. Wood there with you when you signed it? She's read it to you and explain everything to you and answer any questions you had? And do you think you've had enough time to fully consider this matter before making this decision? Were you forced or rushed in any way into doing this? You're entering into this agreement voluntarily. You're not?
No, I yes.
Okay, okay. So you're doing it of your own free will based on circumstances you're in.
Yes, sir.
Okay. Now, on page 1, it says you're going to withdraw your not guilty plea, plead guilty to count 1, aggravated trafficking of methamphetamine under 2925.03A1, a fourth degree felony. Further states that you understand that the maximum prison term for that is 18 months, the minimum is 1 as opposed to 6. There's a fine available of up to $5,000 and possible license suspension 6 months to 5 years. You understand that? And are you facing any other current charges other than this one in this court?
I don't believe so. I think I have a PD in Clinton County though.
Okay. All right. Well, if and you were just sentenced to prison from this court in another case, and so if you are convicted in this court, in this case, and sentenced to prison, that term will be consecutive to that sentence. And I don't remember what that was, but whatever it was, this would be added to it. Then if Clinton County decided that you should be sent to prison for PD up there, that's available. And if there is a prison term imposed up there, he could also be ordered to be served consecutively. That'd be up to the judge in Clinton County. You understand that? Okay. Now, other than these 3 cases we talked about, are you on probation, community control, parole, or post-release control from any other jurisdiction? Okay. Now, under the law, Ms. Holsinger, if you are convicted and sentenced to prison in this offense, then upon completion of the prison term, it is possible the parole authority could put you under post-release control at their option for a period of up to 2 years. If they do, you'll be supervised by a parole officer, and the terms they set, the court has nothing to do with that. If they determine that you fail to comply, they can return you to prison, even though you serve the entire term set by the court for an additional period of up to 9 months of your total sentence for 1 or more violations. But there's a cap of 1/2 of whatever prison term has been ordered to be served between this case and the other case. So that would be the cap. Now, if you committed a felony, though, while under post-release control supervision, then the law provides that the judge in that new felony case, in addition to imposing a sentence for that offense, would also sentence you to an additional period for committing that offense while under post-release control in this case of 1 year or whatever time would be left on the post-release control, whichever is greater. Again, if that happens, that has to be served consecutively to the sentence in the new case. You understand that? Right now, under the law, the court doesn't have to sentence you to prison for this offense. They can't impose community control or non-prison sanction, which means that instead of going to prison, you put under supervision of the probation officer for a period of up to 5 years, under term set by the court. And if during that period of time, probation felt you were non-compliant, they would notify you in writing, serve a copy on you, the court would have a hearing, you would be entitled to have an attorney to represent you. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control, then sentence you to prison for 18 months and fine you $5,000. You understand that? Now, the charge alleges in count 1 that on or about March 7, 2021, in Hines County, Ohio, you didn't knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in violation of 2925.0381. So that's the charge of aggravated trafficking of methamphetamine, prison term between 6 and 18 months. fine of up to $5,000 and a possible license suspension 6 months to 5 years. And Ms. Holsinger, do you understand what it is you've been charged with in that count of the indictment, what the state said you did, when, where, how they let you did? And have you discussed the nature of those charges, the evidence of the case, possible legal issues of the case, possible defenses you try to raise at trial, possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with your advice and office in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time? Has anyone threatened you to make you plead guilty here today? Now, on page 2, about 3/4 of the way down, there's looks like about 4 lines that are printed in bold and underlined. So I'll read those at this time. Defendant shall enter plead guilty to count 1. State will dismiss count 2. State and defense jointly recommend 9 months incarceration consecutive to the term of incarceration defendant is currently serving in case number 19 CR 232. Defendant agrees to repay bond money to the Hyman County Task Force in the amount of $40. Now, is that your understanding of the agreement? Does anyone promise you anything other than that to get you plead guilty here today? Under the law, this whole thing of the matter of sentence is up to the judge, not the party. So even though there's recommendation to get 9 months, which is half of the possible maximum prison term, the court's not required to follow that if you plead guilty. Once you plead guilty, and I've heard all the information submitted, if I decide that's not the appropriate sentence, I could sentence you to anything between 6 and 18 months, fine you $5,000, and suspend your license for 6 months to 5 years. You understand that? Now, do you hold any kind of a license or certification from any state agency that regulates any profession or occupation, a governmental agency? You have certain rights you must understand before I can accept your plea. First, you have the right to have counsel. Ms. Witt was appointed to represent you not for the purpose of working the case out, but to provide any defense that might be available to you under the law that you would like her to provide. So, if you decide you do not want to do this, that you want to defend against these charges, she'll still represent you and defend you, including a trial, if that's what you want. You understand that? And under the Constitution, Ms. Olson, you have the right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in this county that are summoned for jury duty under trial day. After they are selected, the evidence will be presented, they be instructed on the law, and then that jury will decide by unanimous verdict between all 12 have to agree on whether the state proves your guilt of this charge. And that verdict, again, would have to be unanimous, all 12 would have to agree. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive the writing, which means you give up the right to have a jury trial, and in that case, you'd have to hold a court or bench trial. And that means that the judge would be the one to hear the evidence of the jury. The judge will apply the law, and the judge will decide whether or not the state proved your guilt by a proof beyond reasonable doubt. You understand that? Under the Constitution, you have the right to confront the witness against you and cross-examine for your attorney. What that means is the witness against you would have to come into court and testify in front of you, your attorney, and anyone else present in the courtroom. After the prosecutor's done asking questions, your attorney will ask questions that's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. You understand that? Under the Constitution, you have the right to use the power of the court to compel a course witness to come to court to testify for you, just like the state. So, if you have witnesses you're not certain when coming voluntarily, your request, the court issues a court order called a subpoena. That forces those witnesses to come to court and be able to testify whenever you want them to do so, even though they don't want to be here. And so, that is the same way that witnesses for the state are forced to come in and testify against you. You understand that? Right now, under the Constitution, Ms. Holsinger, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't, you make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. In fact, no one's even allowed to talk about it, except in one situation. If there's a jury trial and you don't testify, the judge does instruct the jury that because that is your right, they're not permitted to consider it for any purpose. You understand that? Under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of this offense. What that means is that the burden of proof isn't upon you to try to prove you're not guilty, the burden of the state to prove that you're guilty. So you're not obligated to put on any evidence at all to defend yourself in a trial. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charge, which is the highest burden of proof known in the law. You understand that? All right, now originally entered plea of not guilty, that plea denied the allegation that he denied committed a crime and exercised all the rights I just described. If you change your plea from not guilty to guilty, that is a complete opposite of not guilty. The guilty plea admits the allegations in the indictment, admits that they're a crime, but you committed that crime. And that plea, Wage gives up all the rights that I've just explained for you today, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty, Wage gives up the right to a jury or a court trial. Wage gives up the right to confront witnesses against you and cross-examine for your attorney. It Wage gives up the right to use the power of this court to compel a court witness to come to court to testify for you, just like the state. It Wage gives up your privilege of self-incrimination because you're the one saying you're guilty, and that's what she defines guilty. It Wage gives up the presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court, which is what's likely to happen here today. And finally, it Wage gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you the maximum sentence, or under certain limited circumstances, an appeal could be filed, it would have to be filed in 30 days if your sentencing entry be filed. You understand all of that? And are you a U.S. citizen, Ms. Holsinger? And do you have any questions about the charge and possible penalty? You understand? Do you have any questions about the plea agreement? You understand that? Any questions about the plea of guilty, what it means, what the consequences of that would be if you enter here today? You understand? Do you have any questions about any of the constitutional rights that I explained to you? Do you understand those? Okay. Is there anything you need to speak with Ms. Wood about before we go any further? Have any questions about anything that I've explained to you here today?
She did a very good job explaining everything.
Okay. Then is it your decision to go forward and plead guilty to count one under the terms of this plea agreement we just gone over?
Yes.
And as to the plea, or to the charge that alleges that on or about March 7, 2021 in Highland County, Ohio, you did knowingly sell or offer sell methamphetamine, a Schedule II controlled substance, in violation of Section 2925.03 of the Ohio Revised Code, a 4th-degree felony, carrying a possible prison term between 6 and 18 months, a fine of up to $5,000, and a possible license suspension of 6 months to 5 years. How do you plead? All right, thank you. Court finds that on this day, now open court, defendant was advised of all the constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11. Plea of guilty to count 1 is accepted, order filed, and is found guilty of that charge. Count 2 is dismissed. The court will not order a pre-sentence investigation and will proceed the sentencing forthwith since the defense already served a serious term of incarceration in this court, and there is a joint recommendation. So, I'll go ahead and proceed with sentencing. Anything further from the state?
Only those contained in the plea agreement, Your Honor.
Anything from the defense, Ms. Wood?
Yes, Your Honor, I do ask the court to follow the joint recommendation. Ms. Steve attacks and knowing her from her previous case, it's evident that she does have an addiction problem, and so she is being accountable, and I talked with her, and she's looking forward to making the best of her incarceration and basically starting her life over and continuing it in a sober way.
All right, Ms. Holsinger, anything you would like to say? You have
I'm looking, Judge.
All right, this is the judgment report that the defendant being is hereby sentenced to a term of 9 months incarceration in the Ohio State Reform Court for Women. The court finds that this offense was committed while the defendant was under free control in the previous case, that it was a joint recommendation, and that there's 2 separate courses of conduct affairs and 1 single prison term not adequate to reflect the seriousness of the offense, and the sentence imposed is not, in each case, is not disproportionate to the seriousness of the conduct, and the defendant's prior criminal history demonstrates that the second sentence is appropriate to protect the public. I don't have any jail time credit on this. I'm thinking we gave all the jail time credit on the other case, but I'll have to contact the sheriff to make sure that they have a separate time in this case to order that to be applied. Now, upon completion of this sentence, this whole singer, it is possible the adult role authority may put you in close control supervision for a period of up to 3 years. They don't have to, but they can. But if they do, you'll be supervised on the terms they set by a parole officer, and that they determine that you have not complied with those conditions. They can return you to prison if they serve the entire term set by the court for a period of up to 9 months for any one violation. But the limit is half of the prison term for both this case and the other case that I sentenced you to, for all violations. However, should you be convicted of a new felony while under post-release control, then in addition to whatever sentence the judge in that new case imposed on you, the judge is also authorized to sentence in this case for an additional period of 1 year, whatever time left on the period of post-release, up to 2 years post-release control, whichever is greater. Serves and has to serve secondly in sentence in the new case. All right, is there anything further from counsel?
George, how many days of jail time credit?
I don't have it. I'm going to have the bail, get a hold of the jail. I think we gave her credit all of it in the other case. I think that when she was arrested, that they applied for that, but I can't be sure. So I'll have the bail contact them. I'll go and add it. Send the entry over and I'll add it.
Okay.
Yeah. All right. Okay. And you're remanded back to custody, Ms. Holzer. Thank you. And Mr. King, we also have this 2 o'clock hearing on the Stevens versus Clerk report, although I don't see anyone here present, but we all will do this case first. So, Ms. Wood, come on over, thank you.
Okay.
Go check your mark. I should see if Mr. Stevens is in the building. Come on in.
I texted Lieutenant Brown about the judgment.
Okay.
Said nobody was out there.
Yes. Sorry, yes. Should be.
What's that?
Summer.
Oh, yeah. There you go. That's what they call this silver face. Basically, what I have to see that it's supposed to be here shortly, then can review that PSI summary there. All right, this is case number 22 CD 0040, Ryan Stevens, Iron County Court. This is a application for order to issue a certificate of title to a vehicle that was done record the state that the applicant purchased the court set today's hearing at 2 o'clock. It's now 2:25. Mr. Stevens is not present. The assistant prosecuting attorney, Mr. King, is present on behalf of the clerk. The prosecutor's office did file a response objecting to the issuance of the title on several bases, including that search of the records didn't show either the VIN number or the title number, and that they felt it is not complied with 50510A in order to prove that he's entitled to a title. And since he's not prepared to prosecute the case, the court will dismiss the matter at this cost. All right, well, there's a PSI there for this one. All right, this is case number 21 CR 153. State of Ohio versus Desiree Pace. Bearing on behalf of the state assistant prosecutor King. Bearing on behalf of the medicine attorney Daniel Witt. You are Desiree Pace.
Yes, Your Honor.
All right, Ms. Pace has entered pleaded guilty to theft by deception, a 53 felony. The matter was referred to the probation department for a pre-sentence investigation. And they have received that and reviewed the same. Each of the attorneys had a summary to review.
Yes, Your Honor.
All right, anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor. The restitution in this case, $1,576.80 to Kelsey Fox. Thank you.
All right, Ms. Witt, anything to add to that?
Yes, Your Honor, we ask the court to follow the joint agreement. Desiree has been quiet and very, I think, helpful and proactive in her case, and we ask the court to follow the joint recommendation.
All right, Ms. Pace, anything you'd like to say? All right. It's a judgment on the court then that you be sentenced to a term of 3 years of community control over these conditions. First, you're to obey all laws of all jurisdictions, conduct yourself in all manner and all time, and report when and as directed. Must be truthful in all statements made to the probation department and answers that you give to questions they ask you about your condition. Must keep them informed of your residence and place of employment at all times. You may not change either without prior permission. May not leave the state of Ohio at any time without prior written permission. You have to have that pass with you if you are out of state. May not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who is inmate in those facilities without prior written permission. You're not permitted to purchase, possess, own, use, and have in your control any firearms, ammunition, dangerous ordnance, weapons of any other type. You're not permitted to purchase, possess, use, or have in your control any kind of controlled substance, drug abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has effects similar to controlled substances or drugs of abuse. Or any instrument, device, or thing that may be used to administer them or prepare them for administration unless you have a legal prescription, and you must provide a copy of that within 24 hours of receipt. You submit drug testing when and as requested. Do not purchase, possess, use, or have under control any kind of alcoholic beverage or may be present places with the soul, being facility, and that's otherwise lawful. You're not to associate with anyone as a co-defendant in this case or any other person that has a criminal record, member of a gang or other criminal group. Or any person that has the past or could in the future once you commit a criminal offense or violation of these conditions, unless approved in writing by your supervising officer that apply to any family members that may fall within that definition, unless you live with them even before this offense was committed. To the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another person without profession. Must report any contact law enforcement, any arrest, citation, conviction, other charge, violation, law, and related to an extra staff. Provide your supervising officer financial information records so you're ability to pay your restitution, fees, costs, can be reviewed by the probation department. If you're referred for evaluation assessment for any kind of treatment, therapy, counseling, training, other educational programming, and you undergo that assessment, and if there's any recommendation that you undergo any programming, you're to enroll in and follow that during the period of this community control. You must make arrangements to pay court costs with the clerk, and then make payments in accordance with that. You pay restitution in the amount of $1,576.80 to Kelsey Fox in monthly payments. And that will begin July 1st, 2022, and 1st of each month after that. Those payments will be made through the victim witness office, escrow account, for paying service fees that are charged for that. Now, are you employed this time?
No, not really.
And are you looking for a job?
I was, but with this charge, I had a job, and then after this charge came across with my background check, it was denied. So
You're
I'm still,
seeking employment?
I'm looking to seek employment,
And,
yes.
And remain employed once you have a job.
Okay.
Having a felony record is not the same problem that it used to be in terms of factory jobs or service jobs that don't involve money or whatever, but I know it can be a problem in some cases, but so you need to get a job to pay the restitution. Now, by being placed on community control rather than being sentenced to prison, you're being consented to a search without a warrant of your person and residence, vehicles owned by you, used by you, or any other property places under your control where you're found at any time, any officer of the probation department. Won't be inclined to impose. Now, as far as the restitution is concerned, the reason I set that up on payments is so you can get paid within the 3 years, because if you don't, we can extend this up to 5 years. That it makes life for people more complicated. So we need to ability to work on getting this restitution paid. Now, in the event that it's alleged that you have also your order to pay the court costs as a subsequent order, if you don't do that, don't make payment arrangements. And the clerk can collect that through various means, including ledger of bank accounts, where you can arrange other assets you may have. If that doesn't collect it, then the court will review service and give you credit for each item order. In an hourly rate, something like for each item order, reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file a written notice of report. There will be a hearing held. Will be entitled to have an attorney. If the outcome of the hearing is that you have failed to comply, and at that time the court will revoke your community control and send you to prison for 12 months and fine $2,500. If that happens, once you complete the prison term imposed by the court, the adult parole authority may, their option, place you under what's called post-release control for a period of up to 2 years. They don't have to, but it's optional, but they make the decision, of course, not involved. If they do, you'll be supervised in the terms they set by a parole officer, and during that period of time, if they determine that you have failed to comply, they can return you to prison, they can serve an additional period up to, in this case, half of the prison term for one or more violations. However, if you violate, or if you are convicted of a new felony on the post-release control, in this case, then an additional written sentence could be imposed by the judge in that new case. The judge could also sentence you for committing that new offense while under post-release control, in this case, to an additional period of 1 year, whatever time left on that post-release control time, whichever is greater. If that occurs, that must be served consecutively the sentence.